Well, good morning, good afternoon, or good evening, depending on where everyone is joining us today. A very warm welcome and thank you all for joining us for today's webcast on managing ethics and compliance challenges in Latin America. My name is Kevin McCormack. I'm the Vice President for Global Thought Leadership and Programs at Ethisphere, and my role today is really to help facilitate the discussion for the program. Today also marks the launch of our Latin America special report that Ethisphere just published in partnership with our friends from Control Risks. And over the next hour, you'll be hearing from three of our contributors to this special report on Latin America, and I would like to introduce them now. From Control Risks, we have Geert Albers. He's a longtime collaborator with Ethisphere and serves as the Senior Partner and Head of Brazil and Southern Cone for Control Risks. We also have Mason Pan, Geert's colleague from Control Risks, who is the Principal for Compliance Forensics and Intelligence Practice for the Americas. And of course, we have Rudy Rivera, who I had the pleasure of working with at our Latin America Ethics Summit last year in Miami. And Rudy serves as the Chief International Counsel for Fidelity National Title. Before we kick off the discussions with today's presenters, I wanted to briefly highlight the report itself and go over a few housekeeping items, but let's check the housekeeping box first. First, if you have ever joined us for an Ethisphere webcast before, you know we do love to take your questions and answer them throughout the presentation if there is an appropriate time to break from the discussion. You can submit those questions in text format within the questions field in the GoToWebinar experience. And my colleague Chelsea Domenico is also on the line to help manage that and answer any questions you might have from a logistical or operational perspective. We will also reserve up to 10 minutes at the end of the discussion to address some final questions as well. So again, we encourage you to ask the presenters anything that might come to mind throughout the discussion so we can make this even more of an engaging experience. Of course, rarely do we have the opportunity to address all questions, so if we happen to run out of time, we will be following up with you via email. So thank you in advance. And as a thanks to all joining us today, we will be sending the published version of the special report on Latin America, as well as a link to the recorded webcast and PowerPoint slides shortly after the program concludes. So do look for an email that will be sent to you with the information and the links and necessary details included. Like all of our special reports, the one on, and we've published a number over the course of 2018 so far, but the one on Latin America has some outstanding contributions from a diverse set of organizations and the leaders from those organizations, all of whom have a substantial body of work across Latin America, businesses and operations. The report goes beyond the focus of our discussion today to include some additional perspectives like the M&A environment, conflicts with the code of conduct, building and communicating with the culture, and much more. And you can see some of those highlights on the screen in front of you, some of the contributing organizations and the topics that you will find in the special report on Latin America. So once you do receive it, I encourage you to read through it at your leisure. So with that heavy piece of the introduction behind us, let's quickly move into the conversations with our experts today. And I suppose a good place to start is always with the current state of the business and cultural landscape. And at this time, I'm going to reintroduce Geert Albers to kind of help us set the stage along these lines. And, Geert, I think it comes probably as no surprise to everyone what some of the most glaring headlines have been over the past few years. I think, starting with a lot of the noise and the news around the Operation Car Watch and Petrobras, and then expanding even more significantly in the case of Odebrecht. Is there anything that you can share with us to kind of get things started about kind of this ripple effect, what has taken place in Latin America for the kind of the anti-corruption movement and what we've witnessed over the past few years?
Thanks, Kevin. It's a pleasure to be on this webcast with Rudy and Mason. And thanks for the invitation, and also welcome to all participants throughout the globe, actually, not just the region. I guess the only upside of Brazil losing against Belgium last week is that we probably have a few more Brazilian participants on the call today than originally scheduled. Having lived in Brazil for many years, my heart goes out to all of you. So just to take a step back, I mean, we see an incredible amount of enforcement across the region, most notably in Brazil. And it wouldn't be an exaggeration, I guess, to state that this whole anti-corruption movement in Latin America started in March 2014, when car wash investigation, the major probe into the corruption scandal of Petrobras, kicked off. We just last month, Operation Greenwich was one of the operations within car wash. It was the 52nd federal police operation since car wash started. So that's an average of one a month, which is pretty impressive. Now, the crackdown on corruption in Latin America has spread and it's intensified since Operation Car Wash. But it should also be noted, I think, that the anti-corruption initiatives and overall enforcement has not been uniform across Latin America. Brazil obviously continues to be pole position on this front, but we're seeing encouraging signs of combating corruption, particularly in some traditionally complex countries like Argentina, Colombia, Guatemala, and Peru. On the other hand, Mexico has seen relatively little progress in terms of anti-corruption enforcement. This may change with under the recently elected President AMLO, who campaigned heavily on the anti-corruption ticket, but not entirely convinced that that will happen. This is still a bit of a question mark. Your question around the drivers, I think, is an interesting one. And I recently participated in an event, Counsel of the Americas, which subsequently issued a report on anti-corruption in Latin America. And I think it's sort of, in that report, they summarized some of the drivers very nicely, and probably serves well as backdrop to this call. First driver I would like to highlight is the growth of democracy. So if we go back, to the early 80s, there were 3 democracies in Latin America, essentially. Currently, almost all Latin American countries, with the exception of Venezuela and Cuba, are. And this means, for example, not only, but for example, much more vocal citizens and, very importantly, much more independent autonomous judiciary and prosecutors' office. I think that's a very important thing to highlight, and we've seen what that has meant in Brazil. A second driver, I think, which is important to highlight, is the rise of the middle class. It's been a pretty critical social phenomenon, and just in the last 15 years or so, 50 million, so 50, Latin Americans have been lifted into the middle class. These are generally more demanding and better educated citizens, and very often also paying taxes for the first time. And the importance of that is they've become much more critical about public services and wasteful spending of governments, and they quickly learn to equate, or at least understand the correlation between corruption and poor public services. The third driver I'd like to highlight is the explosion of social media. Around 600 million Latin Americans are frequent users of social media, and this has made news spread very, very fast. These social networks have also been used as platforms to organize major protests, and we've seen that also, again, coming back to Brazil, leading to the impeachment of President Dilma in 2016. And then the fourth driver, I would say, changes in legislation and increased cooperation between law enforcement. So legislative changes have taken place across the region, most notably in Brazil, but Argentina also recently, and Peru also implemented corporate criminal liability for corruption. And we've also seen an incredible intensification of cooperation and information exchange between law enforcement throughout Latin America. So these drivers continue to be relevant for the entire region, and we expect anti-corruption enforcement to continue. In Brazil specifically, I would just highlight that the investigations have spread well beyond oil and gas, so electricity sector, infrastructure, and most recently the healthcare sector in Rio. The second point I'd like to highlight why I personally think anti-corruption enforcement in Brazil will continue is because there are a huge amount of plea bargain and leniency agreements still under negotiations, and by nature they tend to bring more facts to light. The judiciary and public prosecutors across Brazil are very much taking their cues from what has happened in Paraná, which is the state where the judge overseeing car wash is based. And therefore, we see prosecutions and we see judgments taking place in São Paulo, state of Rio, Minas Gerais, and Brasília. So it's actually a very, very broadly spreading national phenomenon. And finally, I think social pressure will continue for greater government transparency and an end to impunity. So, summarizing all of this, I think we started something in March 2014, which will continue over the coming years.
Yeah, thanks very much, Geert. The drivers in particular are really helpful background and kind of brings us to where we are, up to date on where we are now. And I think considering the fact that we have so many folks on the webcast today that have responsibility at some level, if leading or managing or at a director level of the ethics and compliance function within, pretty large organizations, how do the drivers impact some of the prevalent ethics and compliance risks you're seeing throughout the region, and really how do these ethics and compliance risks tend to manifest themselves?
It's hard to, I guess, we talk about Latin America, we talk about 33 countries. That's a pretty broad region. Culture is very different.
Right.
But some of the mechanisms, I think, and compliance and ethics risks are quite similar. Obviously, it would be amiss not to start off with the illicit activities which lie at the core of the car wash scandal, which is in essence, a corruption scheme combined with fraudulent bid rigging, cartel, price fixing with state-owned owned entities, and diversion of the public funds, which are subsequently channeled into campaign financing. Similar schemes have been seen in other parts of Latin America, but I'd like to highlight a couple of others which we come across quite frequently in the different countries. So, for example, compliance risks in the judiciary, in Argentina, particularly the provincial courts, but also Mexico and Peru, a relatively high degree of corruption, payments made to speed up processes or obtain favorable decisions, and also political influencing. Operational bribes generally tend to be quite problematic throughout the region. So payments made, for example, to government inspectors or to obtain licenses and permits, particularly in the spheres of customs, labor, and tax. I think another area often overlooked is in terms of property rights, compliance risks related to those. In some places, these rights are poorly protected and subject to corruption risk. For example, in rural areas in Brazil and in Colombia. And for example, in Mexico, we see quite intensive collusion between police, judges, and organized crime, narco-trafficking groups, which is obviously tremendously challenging for companies there to manage. And just overall, I would state, although there has been an improvement there, relatively poor governance levels at state-owned companies. Obviously, we saw this at Petrobras, which has since changed dramatically. But we could also mention, for example, Pemex in Mexico, which is one of the largest companies. Here in Brazil, we're seeing some changes with the new State-Owned Company Act, which requires state-owned companies, for example, to make professional as opposed to political senior appointments, and requiring a minimum percentage of independent board members. But progress has been relatively slow on that front, and doing business with these state-owned entities continues to be quite a challenging undertaking.
Yeah, and I just kind of advanced the slide forward to kind of showcase and highlight how high the risks still are, at least according to the index that Transparency International always does such a great job preparing. And of course, they're not alone with other parts of the world, but the level of risk that organizations are facing still tends to be very high across the Latin America landscape. Geert, if you can kind of look forward, do you see this, a shift in this over the next, let's say 3 to 5 years, or do you think we're still seeing this level of risk for years to come?
So we're looking here at the Transparency International CPI index.
Right.
It is I think, obviously by very nature, corruption is difficult to measure, if not impossible. So unfortunately, we're forced to use some kind of proxy, or at least perceptions, probably as close as we can get to try and understand what corruption risks are. I would caution, though, and I did want to address that a little bit later in this webcast, about relying exclusively on Transparency International. It's a very, very good tool. But I think, for example, if we take Brazil, which has been at the center stage of the corruption scandals, we see that the index for Brazil has has systematically Brazil has systematically been downgraded in terms of transparency since 2014, since car wash was unveiled. Every year, the ratings for Brazil have worsened. And it does beg a question, which is Brazil today, 2018, a more corrupt and more problematic country to do business in than it was in 2014? We probably wouldn't be able to get into, we could have probably dedicate the entire webinar to this, but I would argue that today Brazil is probably in a better state than it was. Many more companies have compliance programs in place. Levels of awareness around compliance are much, much higher. And as I mentioned, state-owned companies are starting to take the journey on the compliance front. So, taking Brazil as an example, all I would like to highlight is that I think a natural effect of anti-corruption enforcement across the region is that perhaps perception and awareness of the level and depth of corruption increases, but it may somewhat trail what's actually been happening. And I foresee an improvement, at least in some of the countries, over the coming years.
Yeah, great. And I think, it's certainly tied into a lot of this risk that, and we've seen from a number of these cases, how much potential or propensity there is for litigation. Is there anything that you can tie in there to kind of the how you see kind of litigation risks in light of all of these challenges in Latin America? And perhaps that will be a nice segue into the next section with Rudy.
Yeah, I think Rudy's probably better positioned as in-house counsel to talk specifically about litigation. What I would like to highlight is that when we look at some of the challenges in Latin America, particularly from a compliance point of view, bureaucracy and complexity of litigation is certainly one of them. Is a big challenge for all companies. And I think it goes without saying that, where there is a lot of red tape and where, litigation tends to be a very long drawn out affair, and where it can be very costly, it's obviously an environment which corruption may blossom. But again, as I said, I think Rudy is best positioned to discuss the specific elements of litigation and the complexity across Latin America.
Yeah, thanks, Geert. And I'm going to turn to Rudy in just a moment, but we had an interesting question come up that maybe you're in a good position to answer before we jump to the next section. The question was, what is, and I think it's a reaction to the slide in front of us, what is a country like Chile doing for getting a lower level of corruption perception in South America comparatively to that, let's say, than Brazil and others?
I mean, there are several traditionally it's hard to say, but I would say historically, Chile and Uruguay have been the countries with, let's say the greatest degree of transparency in Latin America. And part of it, I think, they are smaller countries, so not that small, and corruption-free go hand in hand. We look at some of the smaller countries in Latin America, and we see, Ecuador and Bolivia, for example, compared to certainly Brazil and Argentina, have significant degrees of corruption risk. But I think Chile very early on went on the privatization bandwagon, has sought to reduce government involvement in the economy up to a significant degree. I think that's certainly been a contributing factor. And, if we go back historically, certainly over the past, 10 years or so, we'll see that Chile has systematically been, one of the more transparent countries, even by European standards.
Now, thanks for taking a moment to address that question. I appreciate the questions coming in. We started to kind of head in the direction of talking about some of these litigation risks in Mexico and across Latin America. And that is one of the reasons we invited Rudy Rivera to participate today. And of course, Rudy contributed a very insightful article on litigating in Latin America to the special report. And So to kind of transition over to this topic, Rudy, let's maybe start with kind of an overview about how the legal process and the rule of law varies from, an example from US to Mexico or from US to other parts of Latin America, to the extent that you can share your insights and your experience in these regions.
Well, the U.S. legal system, even with all its problems, is very transparent. So as a client, I generally know what's going on. You can go on Pacer, you can go on a number of sites. The court records are public, and litigation in Mexico is not like that. As an example, you don't have access to court files unless you're a party or you get special permission from the court. And by the way, it's not just in Latin America; it's also in Eastern Europe and other places where these records are not public. So, you would think that for such a formal system that the civil law systems are, there would tend to be less corruption, but it's actually the formality in those systems that, tend to get into the corruption. And part of what was mentioned before is, you have very little time to file an answer. For example, you may have anywhere from 9 days to 30 days. And nobody can agree to an extension. And if even if everyone agrees, you can't extend it. The court lacks what we call subject matter jurisdiction to grant it. So that means you're running like a chicken with your head cut off to file an answer. And also, I would comment, based on what I've heard, Greet say, most people really think of the Corrupt Foreign Practices Act and the UK Bribery Act in the transactional sense, and often don't think about, well, how is this going to apply in the litigation world? So, for example, with my experiences in Mexico, for example, I assume that I'm going to lose at the court of first instance because that's where the bulk of the corruption is probably going to be. And if we're going to win, it's going to be in the second or third appeal stage. And so what that does is create a process that can take 3 years. We had one case in San Luis Potosí where we lost. We were hit with, one of our subsidiaries was hit with a $17 million verdict. And as I'm walking out of the courtroom, the court, the law clerk for the judge says, well, you've got all the appeal options at your level, which tell me like we're going to lose. And so that's the kind of stuff you have to hurdle through, and when we lost, we then thought, well, our only hope to win is at the Constitutional Court, where you've got, say, more professional judges as opposed to local judges. And it's not just, with the courts, it's also with the attorneys. You get lawyers who ask for, first of all, Mexico has no bar. I don't know about Brazil, but a number of Latin American countries don't have bars that have any teeth. So you get lawyers asking for high retainers and success fees. And these are actual examples, but one law firm asked for $500,000 plus 20%, as a success fee. So that means that the lawyer is not taking a risk. The client, the in-house person, is taking the risk. You also have corruption with expert witnesses. Somebody may approach your lawyer and say, you know what, for $50,000 for a report that would normally cost $5,000, I can get you a favorable report. And so you really have to worry about those things. And I would say, it sounds disparaging when I say that, but I don't trust anybody in Latin America, especially in the legal system, okay? Because their standards are not the same as those in the US and the UK and, throughout Western Europe. And so you have to watch them more cautiously, and you have to make sure that they understand what it is that you need as a company. So many of my retainer agreements will say you're not allowed to bribe, okay? But you can't just leave it at that. You have to make sure that when you are paying fees and what they're asking you to pay, that if some Department of Justice attorney comes in, says, oh, by the way, what was this amount for? And how can you justify it? And so that's one of the dangers with success fees. They charge them here in the United States for, personal injury work, you get percentages, and you can generally tie it to transaction, but I think it's a lot harder or more riskier when you're doing it in a country that's got a high corruption rate. I would also point out that you know, sometimes you get bizarre advice, you know. In the case we lost, I spoke with one law firm, and he said, well, don't worry about the judgment. We'll just transfer all assets. And really, you're going to transfer them? I asked, don't you have law on fraudulent conveyances? Yeah, but we don't worry about that here. And so you get that kind of advice. And so what I would say as a takeaway from this is you really need to check your people. And I routinely get second opinions to make sure that A, what my lawyers are doing are correct, and you know, that I know, you know, that the second opinion is at least going to give me some comfort. And as a general rule, when I request a second opinion, that person, for example, in litigation, he's never going to get the case. Because what I don't want is somebody telling me, oh, this other person's doing a lousy job, just so he can get the case. It'll go to a third person. Now, you may be thinking, God, this is really expensive, you know, but, you know, in my world, you know, the litigation's anywhere from $5 million to $150 million. So it's worth the expense. It may not be worth it in every case. I think somebody had a question, or?
No, I was going to say, I think it, you know, we're at that point where we are curious about, you know, this kind of the special considerations. You mentioned already the challenge of working with outside counsel with local law firms. What are those special considerations that you're using, or the due diligence you're applying when selecting and working with local counsel in these markets?
Well, in my situation, I've got a lot of experience working in Latin America, so I can talk to them. I know enough about the civil law systems to do it. But, you know, I would recommend that if you're new or you're a small legal department, sometimes people think, well, let me get a big firm. You know, they'll be able to take care of it. And I got news for you. I was working with a big firm in the Ukraine, and I won't mention the name, but they were feeding information to the other side. And the moment I got rid of that firm, you know, and it's a firm you would all recognize, you know, and again, it's not a condemnation of the firm. It's just the one lawyer in the firm. So even that's not a guarantee. There are a number of association of lawyers that go anywhere from the very, you know, small firms to big firms. You know, there's like Lex Mundi, their global law, and Meritas, there's Primaris. And these are all people who will screen law firms for you. And those firms value membership in those organizations. So, I mean, that's not 100% catch-all, but it is a start in knowing that you've got somebody, A, that's been vented, and two, that you've got some control, because one of the consequences is getting kicked out of the organization. And the other thing I would say is, don't take what they say at face value. Because you can talk to 3 different lawyers. I mean, that happens in the state, but you'll get different advice. And lawyers in Latin America, and Gert, I'd be interested in your and Pan's opinion on this. Everyone tells you how well connected they are, and that they're the lawyer that can do this, and no other lawyer can do it. And so, in essence, they try to scare you into thinking, God, this is the only one that can do it. Without this person, you know, I will lose. And I would also caution you on, if there's also scams within the corruption. And what I mean by that is there are people who will say to you, for a certain amount of money, I can make sure that you get a favorable ruling. And you only pay at the end. Well, what they're really doing is not doing anything. They hope that if you win, they're going to come knocking on your door saying, oh, by the way, you won, it was because of me. And because it's a backdoor operation, how are you going to know that they did anything? So,
yeah. So with all that in mind, you know, how do you know, you're doing a lot. You're obviously kind of already anticipating in advance what the challenges are going to be, the potential for some corruptive tactics. How do you prepare your team? How do you possibly work with the compliance leaders within the organization, so everybody comes to the table and has a full plan to you know, to mitigate the risk and deal with these circumstances?
well, number one, don't throw your common sense out the window. If I had a nickel for everyone who said that's how they do it there and they just leave it at that, don't. Challenge them. Even though that's not a legal system you're familiar with, challenge them on it. Now, on the flip side is don't say constantly, well, that's not how we do it in the States, because then you sound very amateurish, okay? But challenge them. There's also, a whole bunch of resources on the net that you can read. There's a World Bank has doing businesses for each particular country.
Right.
For example, if you're buying real estate, you can see what are the steps for buying real estate in Panama. What are the steps for buying real estate, and what are the factors involved. So the more you educate yourself on the system, the better off you're going to be. And honestly, if I'm going into a country that I don't know nothing about, it's worth the expense of getting maybe a 4 or 5 page letter of opinion from a law firm indicating how the system works and what are some of the pitfalls. And it's well worth the expense. How is evidence presented? Who can testify? For example, in Mexico, if you're a party, say you're a defendant and you're testifying, your lawyer's not allowed to be in the room with you because they're worried about this undue influence.
Right.
I had to prepare, for example, in the case of Mexico, because that's where we have most of our litigation, I had to prepare in a little mini encyclopedias how we litigate in Mexico, because then I have supervisors who say to me, well, wait a minute, what's this and what's that? And now that they've got that, they kind of understand when I submit a report, they've already read my, prior mini encyclopedia, and so they understand it more. So I think the key when you're an internal lawyer like me and you're dealing with a team is make sure they understand the system too. In other words, don't be siloed.
Right.
Just because you're litigation, don't stick with litigation. You have to work with the compliance people, So for example, one thing I do in Latin America, and it's worked well for me, is called negative contingencies, where I will pay a small retainer but a reasonable success fee. So in one particular case, I paid a lawyer $80,000, and the fee was going to be 8% of whatever he saved us. Now it turned out it was that lawyer's lucky day, because he got the whole verdict reversed outright, and so he made $1.5 million. But $1.5 million is a lot better than paying 20, and it's also explainable. You can, if you got the Fed knocking on your door, well, you can say, well, look, this was our exposure. We think this fee is reasonable.
Mm-hmm. Yeah, thanks for kind of the deep dive into your universe, Rudy. I'm curious before we move on to the next section, if Geert or Mason have any reaction to that. I know Control Risk works with a variety of organizations and has experience working with law firms as well. Is there any reaction you have to anything that Rudy just highlighted?
So to your point, Rudy, about I'm the person, the right person for this job, and the like. Obviously, there are significant across Latin America. Business is very personal. I think the way people express themselves is, as you're well aware, very much based on personal relationships. And our experience in any case, and our experience is also not only on the litigation support side, but most notably, I guess, on the regulatory investigation side, is that when conducting, for example, investigations in Latin America, it's absolutely critical to have local counsel involved for several reasons. Obviously, they know the landscape. They do have relationship networks, which can be very useful, but I think also for the cultural flavor. But it's also extremely helpful to have U.S. counsel present, particularly if we're dealing with a U.S. company, because I think then we kind of get the best of both worlds. Some practices in the U.S. are more developed, just generally investigations more mature, and I think bringing best practices to the market is very helpful. But I always advise our clients, I think you made an inference to that point. Don't go in with a U.S. mindset or something, because it's you're going to look like an amateur. I think it's very helpful to have the high level professional standards and bring best practices to the market. But I do find the local knowledge and understanding local business dynamics, which are not always that clear for people coming from the outside, extremely critical value adds from local advisors, good local advisors, and of course there are bad ones and good ones.
Yeah, thanks.
And if I can just add something to that, Evan, I also attend hearings. And in countries where I don't speak the language, I have an interpreter in my ear. Now, you may not be able to do that, but when you're talking about a case where your exposure is $90 million and you have to explain to your supervisors, what, if anything, did you do to keep us from losing? And, question I get is, well, were you there? Did you go? Why didn't you go? Then you start getting second guess. Also, being there gives you the ability to assess the situation and also kind of get a feel for, well, is there some ethics violation here or not? Or why are they doing it this way? Than just getting a report in writing from a lawyer that says this is what happened today. And that's where corruption can seep in too, because you're not seeing anything. And by the way, you mentioned, real estate. We are a title insurance company, so we've insured all over Latin America. And corruption with the property registry is also a big deal. And I would caution you, you've got land that's awarded by the government, and sometimes they'll award land that belongs to somebody else, and through an administrative title, and then they're knocking on your door saying, "This is my land." You need to be really careful when you're buying land. Corrupt notaries can go in and falsify a title. That's really still a big problem in a number of cases. Especially when you get more out into the regions, like outside Brazil, for example. I think some of the registries have been destroyed, so you really have no way of, knowing whether you have good title or not. And so people, for example, who buy forest land in those areas, you're going to run a high risk. I had a small adverse possession case claim in Romania on some timberland, and we just said, here, give the land to the villagers. You don't want them beating down the door, small parcel of land.
Yeah, needless to say, no shortage of examples. I want to, in the interest of time, I want to continue to kind of progress the conversation. And I think if we can kind of go back, we've had a lot of discussion about corruption. We want to cover the current enforcement landscape and some of the remediation steps that organization and governments are taking. And in fact, Geert, if we can turn back to you, we actually had a question come in, probably anticipating the direction we were going, asking about, there are several Latin American countries that have or are approving, relatively new anti-corruption laws. Is there a positive reflection on such countries, whether that's Mexico or Brazil, or do they see things going in the same direction? If we look at the FCPA activity that we've highlighted on this next slide, you can see where some of the largest enforcement actions have taken place, and at least 4 of those countries on the list on the right-hand side have been, among the Latin America countries. Geert, going back to you, how are companies responding now to this level of enforcement, reacting to cases like Operation Car Wash and with Odebrecht? More of the anti-corruption focus in these regions, and like with the new laws in Mexico and so forth?
Yeah, so this may sound somewhat trite, but most, particularly larger companies, I think we need to be very careful to generalize too much. But if we look at the larger companies of particularly in Brazil and many other Latin American countries, they're responding as you would expect from rational actors under threat. They've shifted considerable attention and resources to implementing robust compliance mechanisms. Obviously, this is particularly true in Brazil, where I guess enforcement has been most rigorous, but I would say it's a general comment across the region. I guess it's important to highlight that the new legislation that's been put in place, particularly the Clean Companies Act in Brazil, or the General Law of Administrative Responsibility in Mexico, and again, I refer to the laws implemented very recently in Argentina and in Peru, which introduced corporate liability for corruption. Every single piece of legislation that I've just mentioned very much models, FCPA or UK bribery, and place a great, emphasis on implementation of corruption and explicitly state, that these serve as mitigating factors for companies should they run into problems. So the fact that legislation has been implemented, however, does not necessarily mean that it's changing major behaviors. And I think, again, Mexico is probably an example there where a pretty robust framework has been implemented, legislative framework, but we have not yet seen the full benefits of that, if only, for example, because the national prosecutor has not yet been nominated. Now, again, Mexico just recently elected a new president, and changes may be on the horizon, but I think for up to now, we haven't seen too much. Now, generally speaking, companies, when they look at Latin America, and if we go 10 years back, look at even Brazil, we would probably, sitting in a risk manager's chair, we'd probably say, what's the risk of a corruption incident coming to light in Latin America? I'm talking about 10 years ago. I would argue that it was probably relatively low, the probability. And if you then would argue, if something did surface, how problematic might that be? And not, again, I'm not looking at FCPA here, I'm really looking from a local perspective. The general culture of impunity in many of the countries means that the impact was also relatively low. What we've seen since Car Wash has kicked off and the law enforcement or anti-corruption enforcement movement has spread across the region is that this risk, which was almost kind of a low type risk, has suddenly propelled itself into high priority risk for many companies, which kind of explains, particularly if you think about the rational behavior. I'm not looking at the ethics, but simply, where are we most exposed? Where do we need to dedicate most resources? It explains why so much emphasis is being placed on compliance programs. Companies basically, and I think, need to focus on two elements right now. They need to focus on the prevention side, because they are facing new types of risks here in the region, and on the reactive side, they need to make sure that they have proper crisis management plans in place and investigations protocols in place. I won't be able to expand too much on the latter point, but I did want to focus a little bit on the prevention side and what companies can and should be doing and what we see are doing. And I won't address all the elements of compliance because I could be here all day. So I just want to highlight the importance within the compliance program of a risk assessment. And the reason I highlight this is because this is one of the neural centers of a compliance program. It's basically it's a risk assessment which ultimately will guide whether to enter a certain country or market and how to do so, be it through acquisition or a minority share in a company. It dictates the level and scope of due diligence should be conducted in the company's network and third parties. It certainly will allow a company to determine what kind of training and where the particular training should take place. And it also helps the company identify exactly where it's most vulnerable in its internal control environment and what it should do to more effectively prevent and detect fraud in its environment. So again, risk assessment as part of a compliance program and as center to this compliance program, I think is probably the most important element, and we're seeing a huge amount of emphasis being placed on that in Latin America.
Yeah, and in fact, we took a moment just to take a look at Ethisphere's data set as it pertains to our world's most ethical companies honorees and the information that is part of that methodology. I think it's interesting to highlight on a few slides what some of the companies that have been recognized as world's most ethical companies by Ethisphere are handling some of these anti-bribery and corruption controls. Some of the data points are on the next few slides, and it's certainly not an exhaustive list. And Garrett, you already highlighted here the importance of the necessary risk assessments. But we're looking at some steps that companies are taking about, and a lot of it has to do with third-party activity. For example, here, conducting periodic audits of third parties. A high level of organizations are doing that to ensure compliance standards. And then actually some go the lengths of providing their third parties with compliance and ethics training and making that mandatory in some circumstances to mitigate risk as well. And if on the next slide, maybe we with the understanding that so many of the anti-corruption cases and enforcement aspects kind of hinge on that third-party activity. I think it's over 85% of all cases extend to some level of third-party impropriety. What can you highlight for us in terms of some of those third-party pitfalls from a corruption perspective?
Yeah, so the third parties globally are companies' single major corruption risk, and Latin America is really no exception. And what I can tell you and affirm is that all of the major ongoing corruption investigations, and including the ones we do across the region, some way or other involve agents or distributors or representatives or consultants, in any case, third parties. We've seen that it's become increasingly more difficult for third parties to contract with larger companies without having compliance programs in place. So there's a lot of emphasis in ensuring that these companies actually have effective mechanisms or compliance mechanisms in place. And these are kind of contractual conditions for them to actually be able to do business with these multinationals. Some of the measures that we recommend, and they'll be common to other areas or in the globe as well, but I think are just generally good practice for managing a third-party risk, is conduct proportional risk-based due diligence. And what do we mean by proportional risk-based? It's extremely important, obviously, with a company that has thousands of third parties. Unfortunately, funds for compliance are not unlimited, so some level of prioritization needs to take place. But the prioritization really needs to be based on where we most exposed to corruption risk, and that can depend on the nature of the services that third parties providing or the relationship with the company. Volume obviously would be an important one. What level of exposure to government and the like. And suffice to say that when we're talking about thousands of third parties, it's probably important to introduce some level of technology to manage, to both execute and manage this program. The second area I think we've seen a lot of failings and which is extremely important to manage well is to have robust procedures to onboard and register third parties. This includes flagging potential conflicts. We see a lot of here in Latin America, conflicts of interest, related parties and the like. So that's I think an area of particular that requires a lot of attention. The third one is incorporate specific third-party risk elements into a company's internal audit program. So because third-party risk is so prevalent here, it's important that auditors, the internal auditors, do dedicate a certain part of their internal audit program specifically to understanding the third-party risk elements. Then obviously the contractual obligation on third parties requiring them to maintain effective compliance programs. Training for third parties, I think that's a theme globally, but it's starting to become a theme here in Latin America. And one area I think we're seeing more interest from clients and technology is making this more feasible is ongoing monitoring, so of media and also of other public records of your higher risk third parties. This is a relatively cost-effective way to be able to continuously monitor the level of risk you're exposed to via your third parties. Obviously, when we rely too much on a due diligence or screening program, and particularly if this is conducted, once a year or once every 1.5 years, whatever it is, so much changes so quickly in markets like Latin America that you could be very highly exposed in the periods between those due diligence, and it gives a false sense of security. So ongoing monitoring, we're seeing as a kind of general trend, much more interest. And lastly, but again with a word of caution here, including audit rights for the very high risk third parties, for example, distributors. I say this with some caution because we have seen clients who have included audit rights and have not exercised them. And obviously when something does go wrong, one of the first questions is if you were aware or if you were made aware that something wrong may have happened at your third party, why didn't you exercise your audit rights? You had the right to and you didn't. So from a defense point of view, not particularly favorable.
No, and we just actually had a question come up about, whether or not third-party audits might be a better way to better check third parties, and if so, are there any practical tips? I think you seem to have anticipated that question, but would you like to expand upon that at all, Geert?
Yeah, no, so I would agree, or at least I would answer in the affirmative. They are very helpful, if only because of a relatively high degree of informality. Remember, many of the third parties companies employ, we're on a journey right now across Latin America of, maturing compliance, maturing governance and the like. It's unreasonable, I guess, to expect that many of the third parties that companies do business with, particularly the small and medium-sized ones, have robust control frameworks in place or robust governance or even, robust systems. And that doesn't mean that they're necessarily conducting business in the wrong way. It's just that, they may not be able to provide the level of comfort that you would need to ensure that, they're staying on track. So it's helpful to have these audit rights, and we have seen them successfully executed, and we have seen them successfully executed, as a matter of fact, in a cooperative, in some situations, in a cooperative fashion, which ultimately results in the third party being able to remediate some vulnerabilities and internal control environments and policies and procedures and the like. But again, with that word of caution that if you do have the audit rights, if something or suspicion does surface or an allegation is made, you almost have no choice but to exercise that audit right. And if you fail to do so, it could backfire.
Yeah, thanks for taking the time to address that in more detail, Geert. We had another slide here to Geert to address some things around the third-party training aspect. We have some more data points here around what companies are doing to train internally around anti-bribery and corruption. It's a high level of training environment to engage the culture in that way, given the high level of risk. I don't want to spend any more time on this necessarily, because I do want to kind of move on in the interest of time to make sure we give Mason an opportunity to contribute a little bit here towards the end. And Mason Pan from Control Risk was kind enough to kind of author an article together with Geert on the artificial intelligence and data aspects and some of those trends in this space. And, perhaps at this time, Mason, what we're talking about here is really how this can help augment and improve the compliance program overall, and maybe some interesting insights from you on how kind of the Latin America market is uniquely positioned to start including some of these technological developments now. So can you talk to us a little bit about how the companies are using the data, how you're seeing it applied to help remediate and strengthen the compliance program?
Yeah, sure, Kevin. I'll start with why Latin America and Brazil specifically is right for innovation, and then we can talk about how AI and more specifically machine learning, a subset of AI, can help compliance programs. So first, why Brazil? I think that the country, it could be a model for compliance innovation because most of the prerequisites in terms of IT infrastructure, culture, and the right regulatory environment are already in place. So first, most companies in the country are starting from scratch with their compliance programs, which means they can adopt the latest technologies without disrupting incumbent processes and systems, sort of like jumping from faxing documents to 5G data transmissions. So compared to other countries such as the US, where large organizations are hampered by legacy and non-compatible information systems in a patchwork of duct tape solutions, those present challenges to reform and improvement. Second, Brazil is very tech-savvy culture, like Geert mentioned, with some of the highest internet penetration levels and social networking density in the world. So it creates a natural environment for new technologies to prosper. Third, due to having one of the most cumbersome bureaucracies in the world, as I'm sure many can attest on the phone, Brazilians have become quite creative at using technology to overcome such obstacles. And the fact that these technology solutions have become more powerful and cost-effective really makes their adoption much more palatable for companies who've been in cost-cutting mode during the longest recession in Brazilian history. And finally, anti-corruption watchdogs in Brazil, they're in learning mode and they're ready to adopt new technology and analytics enhanced compliance solutions. And we've really seen this reflected in leniency and settlement agreements with regulators that require compliance remediation programs to include aspects of compliance monitoring. So to your original question as to how it supports compliance programs, well, I think first that AI and machine learning shouldn't be viewed in a vacuum. It should really be discussed as part of a organization-wide compliance and risk mitigation strategy, such that the compliance technology solutions, they form pillars of this overall strategy alongside other initiatives and programs such as risk assessment, third-party management, whistleblower mechanisms, ABAC training, internal audit, and so on. So I'll talk a little bit more about the AI technology. So first, I will admit the terms AI and machine learning are probably a little oversaturated in marketing speak, and I'm sure everyone is seeing that all over LinkedIn these days. And that's probably causing some confusion as to what really is, and some healthy skepticism as to what really it can do. So in a compliance context, machine learning is really to simplify, it's a computer model that can ingest, analyze, and correlate large amounts of disparate data and use statistical observations and patterns within that data to make inferences and decisions. It can help you find the smoking gun or the needle in the haystack. But in addition, it can also look for additional needles bearing similar characteristics to previously identified risks. So it learns and becomes more accurate the more data you feed it and the more times it is run, because it incorporates feedback to reduce false positives, false negatives. And in the case of unsupervised machine learning, it can automatically self-calibrate. So in terms of reason why to leverage machine learning is that traditionally corporations use statistical sampling to assess and identify high-risk transactions. The issue is that this process really depends on the judgment of the person doing the sampling, which is subjective, right? So problems arise when a bad apple isn't in the batch sampled, which paints an incomplete or erroneous picture of what the actual risks are. And add to that, as larger data sets grow, they need larger sample sizes to be statistically significant. So whatever method has been traditionally used, as data volumes grow exponentially and geographic footprints expand for global corporations, they need to do more than just add additional headcount to effectively monitor these risks. Because the volume of data generated by these global corporations is a fire hose. The flood of information is going to overwhelm what a single individual or team of individuals can process. So leveraging AI and smart technology can really deliver greater productivity, accuracy, objectivity, and speed of analysis, but it also helps prioritize mitigation and remediation measures. And it finally frees the skilled and finite personnel resources to focus on higher level tasks, such as interpreting and investigating the output of these AI models.
Right. Thanks a lot, Mason. I think, I would be curious, and I'm sure the audience is as well, are there any specific examples that you could share of organizations that have really are kind of ahead of the curve in applying this AI intelligence, especially it relates to compliance or investigative functions? Or are there industries that are adopting this technology in ways that are really moving the needle?
I think broadly speaking, some of the areas that machine learning can be applied to are fraud detection, such as monitoring behavior, looking for fraud rings. It can also apply to the anti-money laundering aspects, flagging for suspicious transactions, anti-bribery, corruption, helping detect abnormal payments, expense reports, invoices, and even for contract review, identifying high-risk contracts, and also sanction screening, flagging payments to kind of OFAC sanctioned entities, watch lists, PEPs. And I know I'm short for time, but I'll just quickly kind of break out, just a quick 30-second overview of AI and machine learning. So AI is broken out into the 4 areas: computer vision, robotics, natural language processing, and machine learning. And within machine learning, there's supervised and unsupervised, and all these make up more complicated models that I won't go into the technical or the math behind it right now. But I think for the main purposes of kind of this audience here, I think people will be interested in knowing more about supervised learning and unsupervised learning. And kind of the main difference that in supervised learning, you're really training the machine, where that you have a target and an action or behavior you're trying to predict. So it uses historical data to predict specific outcomes. So in the context of e-discovery and document review, for example, you might have 1 million documents to review. You can use machine learning to basically feed documents that you mark as relevant and ones that are not. And then the machine learns what those characteristics are, and then it automatically analyzes the rest of the million documents and tells you which ones are relevant or not. So it does the work for you, and it knows what's right and wrong based on the supervision. Hence, the model is supervised. So it learns from you. But the downside is that it does require historical data. So in the example of a fraud context, it needs to have known fraud examples, so it knows what to look for. And then so the weaknesses of supervised learning are kind of complemented by the unsupervised learning, which is where you have unlabeled data, and all you're doing is looking for patterns, groups, or clusters in this data. So a quick example is you're trying to cluster your clients according to the type of products they order, how often they purchase, their last visit, etc. So instead of doing this manually across a large data set, unsupervised machine learning will basically automatically discriminate between the different clients. And in the context of the compliance world, it can be applied to the vendor and procurement data, for example, to cluster your third parties by similar behavior or risk profiles. And it looks for correlations between networks of data, which is really useful for identifying networks or coordinated rings of bad actors or syndicated fraud. So the benefit of the unsupervised machine learning is that it doesn't need to have a known fraud example because it looks for unknown patterns holistically. But the downside is that it's not so good at finding the one-off lone wolf types of fraud, which is better suited for supervised and rule-based models.
Yeah, Mason, thanks so much. I think it's going to be really interesting to see that despite despite getting sidelined a little bit in Brazil with the level of the corruption cases that have taken place, it's interesting that you and Geert have emphasized that Brazil is actually in a unique position to kind of lead the effort on incorporating this type of technology into the compliance function and across the organization. So I think it'll be interesting to track that as time moves on, as these components become more available and more widely used. We are certainly a few minutes beyond our time right now. However, gentlemen, if you're willing to stay on for just a couple more minutes, at the very least, I'd like to capture a couple of questions and then we conclude for the day. Is that all right?
Sure.
Yeah, absolutely.
That's fine.
Great. Thank you very much. And thank you all for joining us. And I understand if some folks have to leave, but I did want to make sure we got to a couple more questions before we officially wrapped. And one question that came in is I think just looking at kind of the enforcement environment today and fighting corruption and bribery. The comment in the question was, do you think that enforcement is the key, or really does it come down to the cultural aspects of the organization itself? And starting by the focus on the culture, as long as corruption is something with deep roots in those communities, do you think culture is the focus point, or do you think it's the reaction to the anti-corruption environment? What should be the primary focus there?
I can
Who's the question for?
start there, maybe.
I'll throw it over to you here, since we kind of talked a bit more robustly with you about these things.
Yeah, so from my perspective, and Rudy, feel free to weigh in, Mason, obviously the enforcement environment creates an incentive for companies and individuals to behave. I mean, I think that's not a Latin America phenomenon, that's a global phenomenon. I do think that it's important, the highlighting the cultural element is very valid. And that's where training is so important, because it does reinforce, a culture of ethics, and or you can reinforce a culture of ethics through training and the like. It's important, however, and I think we see a lot of misunderstandings around cultural differences between U.S., European companies and Latin America, if I may generalize as such, as I am with European. I think it's important to highlight, obviously the differences, understand the differences in Latin America. Generally speaking, for example, here in Latin America, leadership and management styles tend to be very personalized and less formal than you might find in the US and Europe. That in itself is not a problem. It is something which makes it it makes it something a little bit more challenging to try and get people to follow rigidly specific policies, procedures, and the like. and I think balance needs to be found there. When we look at, for example, risk appetite, I think this is another cultural element of an organization where there's quite a difference between, for example, a Nordic company and one based in Brazil or other parts of Latin America. Whereas in Latin America, I would say there's generally a higher degree of tolerance, certainly for political risk and legal uncertainty. And again, this is not necessarily problematic, but it can be very stressful. It can be an environment in which, compliance policies and procedures and the like are tested because, for example, flexibility and creating problem solving are attributes that are very, very much in high demand and almost needed for survival. So I would conclude just by saying, yes, very important to focus on cultural elements as well, but I think it's important not to implement a hard rule-based culture, more of a principle-based culture, that should also be reflected in the training.
This is Rudy. I tend to give more emphasis to the cultural aspects of it, because when you're in an environment where people think the rules don't apply to them, or yes, we've got these rules, but yeah, there's a way around it. As long as you've got that mindset, you're always going to have an issue with corruption. So the key is, how do you program that mindset? Say, especially if you have a subsidiary in that country, to say, no, that's not acceptable. We don't do that. Because I can tell you it could be pretty costly. And so for me, it's a big cultural education. You have to spend time educating the people you're working with down there that you won't tolerate that. And at the same time, showing them the degree of respect that they deserve and saying, this is why we don't do it,
I would tend to agree, and I think that most of the trainings that are actually, I think the most effective trainings conducted in the ABAC space are very, very much focused on core values and behaviors, not on laws and rules. And again, to really reinforce the ethical culture.
Yeah, thank you both for addressing that question. Let's do one more, and it goes back to a question, kind of a follow-up to the third-party discussion, and in terms of the audits. So the question is, could third-party I'm sorry, I just lost it here. I have it again. Still, keeping with the third parties, what is the view of compliance provisions that don't have audit rights? And if a company can't exercise audit rights, is it better not to include them at all? Geert, I don't know if you have any.
Do you want to take that? Or?
Can you repeat the question? You went out on me.
Sorry, yeah, the question was, as we're still sticking with it on the third-party discussion, what is the view of compliance provisions that don't have audit rights? And if a company can't exercise audit rights, is it better to not include them at all? I don't know if anyone's
Rudy, I think you should always include audit rights, even though you may not be able to audit. You should still always include them, because you have to show you're making an effort. And I would say that, I believe in the golden rule. He who has the gold makes a rule. And if, you're paying money to somebody, I think you're in a position where you can insist on those audit rights.
And I think if you have the audit rights in place, even if you don't have the current capabilities, you can always, if there is an issue, you can always bring in outsiders to assist you. So I wouldn't kind of, shut off the upstream possibilities for a downstream action.
Great. I think I appreciate your willingness to stay on a little bit longer and answer these questions. And in fact, it seems like we had a number of the attendees still willing to join us past the hour. So I appreciate their time as well. We had so many questions coming in, it was hard to keep up with the flurry of questions. As I mentioned at the outset of this program, we're going to be following up with individuals where questions we didn't have time to respond to. We'll follow up via email with some level of response or a way that you can get in touch with one of the presenters to kind of discuss further if you're so inclined. Again, I would really like to thank Geert, Mason, and Rudy for their time today and their perspectives, and also for their contributions to the special report on Latin America. We will be circulating that to all attendees, and we will also be posting it to the Ethisphere site. Incredible discussion, probably some of the most questions we've had on any webcast we've done, at least so far this year. I want to thank the audience for their time joining us from a variety of locations around the world. And again, just thank you to all so much. My contact information is on the screen in front of you. Tyler Lawrence, whose contact information you see on the screen, he was the managing editor for this special report on Latin America. I wanted to make sure to highlight him and thank him. And again, thank you all for a great program today, and we look forward to speaking with everybody again. Have a great day.
Many thanks.
Thank you.
Thank you all. Bye-bye.